Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we discuss Mullin versus Otro, Lado, decided 6-3 on June 25th.
The Supreme Court reversed the Ninth Circuit and held that a person standing in Mexico does not arrive in the United States under the federal immigration statutes by attempting to cross the border and getting blocked.
Justice Alito wrote the majority, joined by 5 colleagues. Justice Thomas concurred.
3 justices, Sotomayor, Kagan, and Jackson, dissented. Bottom line, the government can legally resume metering, physically blocking asylum seekers at the border before they step foot on American soil.
Big win for Executive Border Authority.
And 3 justices say a devastating blow to people who traveled thousands of miles and got stopped at the last inch.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. If you caught our preview episode, you know the setup. Spring 2016. Ports of entry along the southern border started buckling under a surge of people seeking admission. Numbers sometimes far exceeded what facilities could safely handle. Officers ran out of chairs, beds, meals, and in November 2016, DHS launched metering. Immigration officers physically blocked people from crossing the border until the port could process them. Not today, come back later.
That sounds manageable on paper.
Until you read what the dissent documented. A 2020 DHS Inspector General report found CBP often cited lack of capacity to justify turnbacks regardless of actual conditions. At ports where detention facilities sat completely empty 80% of the time during metering. A whistleblower testified that officers were instructed to lie to people by claiming capacity limits that didn't exist.
So officers told asylum seekers the port was full, when it wasn't, and the consequences turned deadly. Makeshift camps formed on the Mexican side of the border. Asylum seekers returned from ports faced beatings, assault, murder while waiting. One couple, discouraged after a month in a border camp, tried to swim the Rio Grande. They drowned. A woman and her 2-year-old son drowned attempting the same crossing.
Real people, real consequences. In 2017, asylum seekers and an immigration advocacy organization called Otro, Lado filed a class action in federal court in San Diego, arguing the metering policy violated 2 federal immigration statutes. The district court agreed, certified a class, and declared the policy unlawful. DHS rescinded metering in November 2021, right after that ruling. But the district court still entered its declaratory judgment in 2022. The Ninth Circuit affirmed on a divided panel, and 15 judges dissented from the denial of en banc rehearing, calling the panel's decision gravely wrong. The Supreme Court granted certiorari, the Secretary of Homeland Security changed, and the case went up as Mullin versus Otro, Lado.
What's the legal question?
One phrase. As we predicted in our preview episode, the whole fight came down to arrives in the United States. Section 1225 says an alien who arrives in the United States shall get inspected by immigration officers. Section 1158 says any alien who arrives in the United States may apply for asylum. Both statutes carry mandatory shall language, not suggestions.
So the fight, does arrives in mean the moment you physically cross the border? Or does it cover someone who reaches a port and presents themselves to an officer, even if that officer blocks them at the line? Do you arrive in America when you step inside it, or when you knock on its door?
And the oral argument on March 24th made clear how uncomfortable that question made even justices who ultimately voted with the majority.
Justice Kavanaugh pressed government counsel Vivek Suri directly, calling it privileging the illegal entrant over someone who lawfully approaches the border and follows the rules.
Justice Jackson described a polite asylum seeker who wants to do everything by the book, walks up to the border, doesn't cross because the law says don't enter without authority, and asked why Congress would design a system that rewards the person who broke that law over the one who followed it.
That's the main tension the majority had to resolve.
All right, what did the 6-justice majority decide?
3 moves. First, plain meaning. Justice Alito opened with the dictionary. Arrive means to reach a destination. The preposition in means within the limits, bounds, or area of a place. So you Arrive in a destination only when you enter it, not before, and not when someone blocks you at the threshold.
This case involves some great analogies. You may recall from our preview episode, The Trojan Horse. The Greeks didn't arrive in Troy while camping outside the city walls. The majority pushed further. A running back tackled at the 1-yard line doesn't arrive in the end zone. 6 points don't go on the scoreboard. A guest doesn't arrive in a house when the homeowner locks the door. An army repelled outside city walls doesn't arrive in the city. A letter doesn't arrive in a mailbox when a dog attacks the mail carrier 1 step away.
Justice Alito actually pressed Respondent's counsel with the house analogy during argument. He did. Asked Kelsey Corcoran directly, "Does someone arrive in a house when they're knocking at the door and haven't entered yet?" She said yes. The officer and the asylum seeker stood toe to toe at the line. She offered her own counter. "I'm arriving in Baltimore when I'm on the train heading in."
But Alito noted that throughout the argument, multiple justices kept slipping into arriving at rather than arrives in.
That preposition, he said, revealed the problem with Respondent's entire theory.
Second move?
Statutory context. Other INA provisions, Immigration and Nationality Act, expressly cover aliens who enter or attempt to enter the country. Criminal statutes, arrest authority, all use attempt language. But sections 1158 and 1225 contain no reference to attempted entry. None. Congress knew how to write attempt and left it out of these two provisions deliberately.
And the surplusage problem, because that gave even the majority trouble.
It did. Section 1158 covers aliens physically present in the United States, or aliens who arrive in the United States.
The majority conceded that under its own reading, everyone who arrives in also qualifies as physically present, making the arrives in clause technically redundant. 2 clauses in the same sentence. One does nothing.
Justice Kagan pressed Suri hard on that at oral argument.
She told him his best argument on surplusage was that arrives in points to people arriving right now versus physically present, covering people who sat here for years and later applied. She called it a better argument than everything else he offered. The majority ultimately adopted it.
But the dissent said that explanation doesn't hold. Right, and that's the central debate between the majority and dissent. The majority's answer, the anti-surplusage canon isn't absolute. Congress sometimes enacts redundant provisions. And when IRIRA, the 1996 immigration reform law, created expedited removal, it added arrives in language to section 1158 to confirm that even aliens in that accelerated process could still apply for asylum.
The dissent's answer, section 1225B, already made that abundantly clear. The arrives in clause does no independent work on the majority's reading period. What was the third move?
Go ahead.
Presumption against extraterritoriality. Courts presume Congress writes laws to govern domestic conduct unless Congress clearly says otherwise. Established in Morrison versus National Australia Bank, a 2010 securities case. Nothing in sections 1158 and 1225 signals unmistakable congressional intent to reach people standing in Mexico. Government's reading, U.S. side of the border.
Respondents' reading, Mexican side of the border. Courts presume Congress didn't want that extraterritorial reach. Reversed and remanded, 6-3.
Now let's dig into that lineup.
Let's start with Thomas. Thomas joined the majority in full, every word, but he wrote separately to plant 2 flags for future cases. Flag 1, the class-wide declaratory relief problem. A statute, Section 1252F1, strips lower courts of authority to enjoin or restrain certain immigration enforcement on a class-wide basis. The court confirmed that barring Garland versus Alaman Gonzalez, a 2022 case. The district court, knowing it couldn't issue a formal injunction, issued nominally declaratory relief that produced the identical practical effect.
An injunction wearing a disguise.
Thomas cited California versus Grace Brethren Church, 1982, which held nearly identical statutory language in a tax statute also barred declaratory relief. Because there's little practical difference between the two, he called for the court to address this end run in a future case.
And flag 2?
Constitutional. Thomas argued that if any statute could force the president to bring specific aliens into the country against his will, that law raises serious questions about the president's inherent authority to exclude aliens.
The naturalization clause gives Congress power over naturalization, not over compelling the executive to admit people outside that path. He signaled that such a statute likely wouldn't survive constitutional scrutiny.
So Thomas agreed with the result, but quietly handed future administrations two tools to further narrow what immigration courts can order.
That's the Thomas playbook. Now the dissents and the fractures there deserve equal attention, because the three dissenters aren't fully unified. Sotomayor wrote the main dissent, joined by Kagan and Jackson. Her core argument, arrives in the United States, covers people in the process of arriving at the threshold of a port, regardless of whether they completed the crossing. She grounded this in the present tense of the statute: arrives, not has arrived, plus nearly 30 years of federal regulations defining arriving alien as anyone coming or attempting to come into the United States at a port of entry.
On surplusage, she invoked Marks v. General Revenue Corporation, 2013, for the principle that the anti-surplusage canon carries maximum force when two clauses sit in the same sentence. The majority's expedited removal explanation fails, she argued, because Section 1225B already made clear those aliens could apply for asylum.
And then the MS St. Louis,
the 1939 ship carrying 900 Jewish refugees turned away by Cuba, the United States, and Canada. Over 250 later died in the Holocaust. She raised it at oral argument, and in the opinion, Congress passed the Refugee Act of 1980 in direct response to that tragedy.
Under today's ruling, she wrote, if those refugees walked up to a southern border port today, immigration officers could turn them away, even at a port with ample capacity, even if turning them back would result in the very persecution from which they narrowly escaped. Final line, more people will die.
Jackson wrote separately on mootness, and that's the fracture within the dissent. DHS rescinded metering in November 2021. No current policy exists. The government said only that it seeks to retain the option. Jackson argued the court should never have taken this case. She raised it at oral argument directly, asking why the court couldn't simply vacate the lower court's judgment instead of reaching the merits.
Without a live policy, she said, the majority interpreted these statutes in a complete factual vacuum, using metaphors about running backs and house guests instead of actual border operations. Her line, the court is not a law student puzzling through a difficult cold call. She joined Sotomayor on the merits, but would not have reached the merits at all.
So Sotomayor and Kagan accepted the case as properly before the court. Jackson joined them on the merits, but thought the court should have stayed out entirely.
A meaningful fracture? Jackson's mootness argument could resurface the next time a challenged policy disappears before a case resolves. The voluntary cessation doctrine, the exception that kept this case alive, may not hold in every future variation.
All right, let's talk about what this actually means. The government can now resume metering at southern border ports during surges. Until a non-citizen physically crosses the border, the inspection mandate and the right to apply for asylum under Sections 1158 and 1225 don't attach.
Officers face no statutory obligation to track who they turned away, schedule future appointments, or create a wait list.
What challenges survive?
A separate APA claim, Administrative Procedure Act, that even if metering doesn't violate the asylum statutes on its face, using it as a subterfuge when ports have ample capacity could still qualify as arbitrary and capricious. That claim didn't reach the court today, and Thomas's two flags, the Section 1252 F1 class-wide relief fight and the Presidential Exclusion Authority question, signal where future battles may erupt.
Bottom line, on Mullin versus Otro Lado, 6 justices drew a hard geographic line at the border's edge. 2 letters, IN, determined whether hundreds of thousands of people can claim federal asylum protections. 3 justices said that linguistic call carries a human cost too high to accept. Thomas said the majority didn't go far enough.
And Jackson said the court shouldn't have drawn any line at all.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report, and if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And if you want your review to arrive in our podcast rankings, you've got to actually cross the threshold and hit the button. Hovering near the app doesn't count under the majority's reading.
Talk to you soon.